Hello, everyone. Good evening. It is my pleasure to welcome you to SCL India's FIDIC series, and especially so because this is the first session of six that we are set to have. Let me begin by complimenting SCL India for taking this initiative and the driver group Heating Chambers and Ketan and Co, where I work, for supporting it. Um, we will begin by hearing opening remarks from Mr. Ratan Singh and Karthikey Mahajan. Ratan Singh is a senior advocate based out of Delhi and a heavyweight construction arbitration practitioner who's acted as lead counsel and arbitrator in some of the most complex construction arbitrations concerning projects in India. And he's also an international member of Heating Chambers. Karthikey is a partner at the Singapore office of Ketan and Co. He's a triple qualified lawyer in India, England and Wales, and the state of New York. Karthikey's primary area of practice is international arbitration, both commercial and investment, and he has acted for parties under all leading arbitration rules, ICSID, ICC, SIAC, and the LCIA. With this, let's hear opening remarks. Mr. Singh, would you please be happy to?
Yeah, I can hear you, Jatan, and
Yes.
thank you for your kind introduction. Good evening from India. As founder and chairman of Society of Construction Law India, it is my pleasure to welcome you all to this first session of SCL India series on FIDIC contracts. Today is the first session of the six-part series where we all will delve into various FIDIC contract forms and their operations and applicability in the Indian as well as international context. We are grateful to our partners, Heating Chambers London, of which I am an international member, Ketan and Company, Driver Trade, for collaborating with us and supporting us in the endeavor. Lots of preparations have gone into this. In fact, I remember on 18th of December 2022, I was sitting in Heating Chambers in the boardroom and talking to all those speakers from Heating Chambers who are speaking in this series. And it was preparatory meeting where we had gone into the nuances of this whole series. Again, SCL India has a few people who have really worked tirelessly for this. Mr. Gracious Timothy Dunna, Mr. Jatan Rodriguez, Mr. Raghav Murthy, all of them worked tirelessly to see the success of this event, which is one of its kind so far as India is concerned. So far as FIDIC is concerned, we all know that it publishes general conditions of contract that are widely used for international construction contracts. They are intended to be used in any legal jurisdiction. FIDIC general conditions are explicitly based on a fair and equitable risk allocation between employer and contractor and are widely recognized as striking an appropriate balance between the reasonable expectations of the contracting parties. What I wish to say is this: FIDIC forms are used globally in two ways. One, in its purest form. So if it is red book, whole form remains red book. And there are situations where employer invariably changes the stipulations in such a manner that only red book, where only red cover remains and everything else goes. In India, FIDIC is used in both these forms, both these avatars. So you have a lots of mega projects going on where FIDIC form in its original shape is being used, but there are employers who are using forms which are influenced by FIDIC forms, but they are not really FIDIC forms because of the imbalance they create by allocating risks against contractors in such a manner that it creates problem rather than helping the employer. Employer would believe that by putting more risk on the contractor, employer gets to gain out of it. I'll refer to one particular study on this. That is the Japan International Cooperation Agency, JICA, commissioned the Association of Japanese Consulting Engineers to prepare a checklist for one-sided contracts to be used for preparation of reasonable bidding documents. JICA noted that if modification of a particular project altered the originally contemplated risk distribution in the FIDIC book to a large extent and the risk allocated to the contractor becomes excessively high, the following problems may occur. So that is the warning, and I'm reading what are those risks. If you create an imbalance, higher bid price, bid failure and disruption of project implementation, non-participation in the bid by consensus and capable contractors, contract award to a bidder who failed or was not capable of estimating the risk properly, poor construction quality and delay to the progress of the work due to lack of risk contingency, undermining the relationship of mutual trust and respect between the employer and the contractor, repetition of groundless claims from the contractor, frequent disputes between employer and the contractor, and in extreme cases, termination of the contract. So therefore, the consequence of inappropriately allocating excessive risk to the contracts can actually have the opposite effect to that desired by increasing the employer's risk. So therefore, this is not at all a great idea to tweak with FIDIC forms which are prepared by all stakeholders sitting together, realizing where risk lies and where it should lie. Now, what is that we are going to learn in this series? We are going to understand about the underlying philosophy behind contractual stipulation in terms of these FIDIC forms. What are the philosophy, why it is written the way it is written, and how and why risks are allocated. I must tell all the audience, including from India, and particularly from India rather, that even if you are not using the FIDIC form for a particular project, most of the contractual terms are influenced by FIDIC terms. So therefore, don't assume that since you are not using FIDIC form, therefore this series is not important for you. It is very important for you for the reason I have just mentioned. Now, so far as India is concerned, with an investment of 1.4 trillion rupees, India is on its way to become a hotspot of construction and infrastructure activities, attracting shareholders and stakeholders from across the globe. As we see increased involvement of international players, it is imperative that India adopts international best practices with FIDIC forms of contracts playing a central role. It is not that FIDIC contracts are an alien concept in India. The contracts have been successfully or otherwise adopted by Indian employers in various projects. But every jurisdiction is unique and comes with its own set of problems and peculiarities. At Society of Construction Law India, it is our aim to improve the construction ecosystem in India and enable all stakeholders, be it employers, contractors, engineers, consultants, lawyers, and even arbitrators and judges, to better appreciate the modalities of a project. The key idea is to bring all parties on the literal and figurative same page and avoid disputes and ensure smooth operation. Any construction contract works at two levels. One, the express provisions of the written agreement, and two, the law, statutory or judicial, which superimposes itself on the contractual provisions. The series will touch upon the following aspects: contractual guide, Indian perspective, and international perspective That is the foreign law. With this, I welcome you all and hope you have a great and fruitful session in this entire series with such a great panel you have today, and you will have on all those next sessions. Thank you very much. Thank you very much once again.
Thank you very much, Mr. Singh, for those encouraging comments. Karthikey, we welcome you to share your thoughts.
Thanks, Jatin. Thanks, SCL-India, for having me here. I mean, with that opening remarks, I really have very little less to say to add to it. The only thing that I would say is that in India, we see this constant buzz when it comes to infrastructure investment. And it's not only people in India, it's not only contractors in India, it's contractors from across the world, as Mr. Singh just pointed out, who are looking at investing in India, and having a FIDIC contract is now a point of discussion for some of them. In fact, very recently, we were looking at one contract for one of our clients, and they wanted a FIDIC contract. But I think as the situation stands in India, it's not a norm. But hopefully at some point it will become a norm, because increasingly Indian ways of creating infrastructure projects will get internationalized. And adopting FIDIC is just the beginning of it. I commend SCL India for taking the initiative to tell the entire audience about the basics of FIDIC contracts, because as far as I can tell, there is no course in any Indian law school that goes through FIDIC contracts. So I think it's a great learning experience for everyone involved in the construction industry, the legal industry. And I think all the lawyers, all the engineers, etc., all the stakeholders will benefit greatly from it. And thank you for taking the effort to put all of this together. And we at Khaitan are very happy to support this initiative. Thank you.
Thank you, Karthikey. So, with having heard opening remarks from Mr. Singh and Karthikey, we now move on to our panel discussion. What we have set out today is an introductory session into what the FIDIC suite entails, who FIDIC is as an organization, what the different books are, how risk is allocated, what amendments employees commonly make to the books. And we have a stellar set of speakers with us today to take us through all these issues. So allow me a brief moment to introduce our speakers, and following that we shall begin. Let me start first with Dr. Adriana Spasova. She has a PhD in construction project management and 2 master's degrees, one in civil engineering and in construction law. She's a FIDIC trainer and sits on the FIDIC committee as a vice chair. She has 36 years of professional experience as a designer, construction manager, and consultant. And specific to FIDIC, she has 26 years of experience in energy, railway, industrial facilities, waste management, and water infrastructure projects. In the last 6 years, she has to her credit having trained more than 1,600 participants in over 30 countries, which is quite an impressive feat, and we are very happy to have her with us here today. Next, we have with us Jenny Wild, who is a barrister at Keating Chambers in London. Jenny specializes in high-value construction disputes, both in arbitrations and in litigation before English courts. She has acted under all major rules such as the ICC, the Dubai International Arbitration Center, and the UNCITRAL rules. She has multiple rankings as a junior construction barrister, and she has also been featured in 40 under 40 top lawyers in the construction industry. Again, Jenny, we are happy to have you here with us. Then we also have Venkat. Venkat R, who is a chartered engineer, a chartered quantity surveyor, and a construction lawyer. He is a fellow of the Chartered Institute of Arbitrators and a fellow of the Cost and Management Accountants. He, in the construction industry, he has had experience acting as an arbitrator, an expert, a mentor, and a trainer. And that's what we hope that he will do with our audience here today, also train us and mentor us into FIDIC contracts. Lastly, Venkat is also the founding partner of C Cubed Consultants Limited, which is a project consultancy firm that caters the construction industry. And he has, through his organization and otherwise, multiple decades of experience uh, managing and consulting on projects in Asia. Last but certainly not the least, we have Paul Batrick with us, who is managing director of the Driver Group. Paul has over 40 years of experience in the construction industry, and he has acted in the capacity of an advisor to employers, consortiums, contractors, subcontractors, and on projects spanning multiple countries, including Europe, USA, Canada, uh, countries in South America, Africa, the Middle East, and Australia. In addition to his project consultancy work, Paul also advises clients specifically on dispute resolution, issues that arise in construction disputes. And uh, in this context, he has also acted as an expert witness in arbitration proceedings and before English courts. So we have, as you would have seen, an extremely stellar panel with us here today with a collective experience of more than a century. And we will begin with hearing from Adriana, who will take us through who the FIDIC is, what the books in the suite are, and why they were created. And yes, Adriana, I shall.
Thank you for your kind introduction. Thank you for the invitation. And I want to congratulate you for this initiative as Vice President of the European Society of Construction Law, and wish you good luck with our sessions. So what is FIDIC? This is a French acronym, Fédération Internationale des Ingénieurs Conseils, because three French-speaking countries, Belgium, France, and Switzerland, founded FIDIC 110 years ago. It is very interesting that the founding principles, quality, integrity, and sustainability, are very important even today. So it is leading the consulting industry against being the global voice, being the nexus for all stakeholders, and FIDIC is facilitating improvement and growth in the business, which is related with construction, and of course relating all its documents with the global challenges. We have more than 100 member associations. Only one member association can become a member from a country. So as you can see, this means 1.5 million professionals represented in the federation. This is the global structure of FIDIC. You can see that there are several regional organizations, and there are some which are under formation. And here you can see that there are 9 committees which are active, and we are very interested for this workshop in the activity of the contracts committee. So you can see here Vincent Leloup, who is the chair of the contracts committee. And of course, the board is overseeing the work of all committees. So now we are talking about the FIDIC body of knowledge, because besides the contract, we have guidance, we have FIDIC Academy for trainings, and now we have a new entity, which is FIDIC credentialing. This entity is involved with the certification process. So we have 66 years leadership with the contracts, because the first contract was the original Red Book, which was issued 66 years ago. And after that, there were many editions, but at some point of time in 1994, FIDIC set up a task group which had the task to prepare a suite of books for works contract, which became very famous as the Rainbow Suite, because all of the 3 books for major projects, which are very famous, those are the red, yellow, and silver book. They have 20 clauses, and they are very similar, with some differences depending on the risk allocation. So I'm very grateful that this event started talking about the risk allocation by Mr. Singh, because this is in the center of FIDIC contracts to have fair risk allocation, and it is very important for the selection of the contract to select the contract according to the risk allocation. Now we have the new 2nd edition of the 99 books, and this was done 18 years later in 2017. And after 5 years being on the market, we have the reprint, which was issued in the end of last year. So the reprint, 2022 reprint of the 2017 edition is active from 1st of January this year. We have several families of contracts. We have these agreements for services. We have the works contracts with different colors, and everyone talks about them because of the color of the cover. So we have the white book, which is the central one in the agreement suite. We have here the famous red, yellow, and silver book, but also we have the blue-green book, we have the gold book, we have the green book, and we are waiting for the bronze book. So you see there is a good choice of different standard forms. And besides this, we have the guides. So for those of you who are working with the 99 edition of the red or yellow book or silver book, I would recommend you to go to have this guide and use it, because it compares the 3 contracts in 3 columns and explains every clause. And now we have the new guide, which is for the 2017 edition. Besides, we have different guides, and I would recommend to consultants and employers also to use the procurement procedures guide. And a special slide for the jewel of the books. For me, this is the best FIDIC form, because it is very concise. At the same time, it has the fair risk allocation. So if you want a short form, because the general conditions are 26 pages, you can buy the new 2021 green book, because you can use it for any type of payment. You can use it for different projects with the design by the employer or by the contractor. So why FIDIC contracts became so famous? Actually, books commentators in the field are confirming that FIDIC contracts are most used international contracts, and they have a long history, and they can be applied both for common law or civil law jurisdictions. This is because they have general conditions with fair risk allocations, but they are made to be used internationally because they always take into account the governing law, which can be different from the law of the country, and they take into account also that you have to comply with the provisions of the law of the country of the site. Also, you can tailor this for your projects, developing the particular conditions in line with the golden principles. And you can use the books for different types of projects. So you select the book because you want a specific risk allocation, for example, the design to be prepared by the employer or by the contractor, but you can use them for any type of projects. So if you have a standard form which is well known, the cost for the risk will be lower, so you shall have better competitive tenders. International contractors are using these forms everywhere. You have also good training programs, and here you have a multi-tier dispute resolution process, which is developing very well now in the new 2017 edition. We have for all types of contracts now the standing dispute board, then amicable settlement procedures and arbitration. So you can use these forms with confidence that you have the right tools. The new forms which were issued in 2017 widely used at the moment for new projects because the main multilateral development banks have signed license agreements with FIDIC, and they are going to use and are using already for the new projects the new forms. Also, some bilateral agreements have been signed with KfW, JICA that you have mentioned, and other agencies and banks. We have a lot of stakeholders and important users. That's why the FIDIC contracts are so popular. So we have different colors of the covers, but what is inside? We have different risk allocation. So in order to select our form, we have to know what is on the market and how to use it. For example, we have a new form, which is a very good one for underground works, which is mixing a bit measurement with lump sum because the underground works have a lot of risks. This is so-called emerald book. We have a specific form for dredging works, which is popular as the blue-green book. We have the short form, the green book, the new edition is the one recommended, and we have the famous red, yellow, and silver book. You know that the red book is preferred because when the employer has developed the design, the employer keeps the design risk, and the yellow book is where the contractor is designing. You shall hear from Jenny more about it. And we have the silver book, which is an EPC turnkey contract. This contract should not be used in case of risks which are underground, which the tenderers cannot estimate during the tender preparation. And we have the gold book, which is for operation, not only design and build. We have also these forms which were issued in 2017 as the latest edition of the White Book, and these books which are used with the White Book, which are for the joint venture agreement for the consultants and the sub-consultancy agreement. And we have two subcontracts. We have a subcontract for the Red Book 99 and another one for the Yellow Book 99. We have seen the sales recently, and it is obvious that people are confused with those subcontracts because now they are buying more this form which was issued in 2019. It is not like you have to buy the latest form. You have to see which one you need. If you have 99 main contracts, so you have to use this one for subcontracts. If you have a main contract which is under the Red Book, you have to use this one, though it is issued in 2011. It doesn't mean that it is an old version. No, it is used with the Red Book. So the MDBs are no longer having license agreement for this famous pink book, which is a harmonized edition of the red book. That's why I have stricken it, because maybe you hear about the pink book, but it is no longer being in the tender documents. There might be some projects going on. So just to go shortly through the algorithm for selection, the basic algorithm for selection of a FIDIC form. First of all, we have to ask ourselves, do we have a project with major risks? If not, we can select the green book. So if we have a project with major risks, then the next question is who is taking the risk for the design? If the employer is the one, then we are using this red book, which has a subcontract. If not, if we would like the contractor to be responsible for the design, we have here several choices. We can have the emerald book, which is 90% yellow book, but it is for underground works. So in this emerald book, this lining and excavation works, which depend on the soil, they are measured, and the other lump sum, and all the provisions are very similar. So the next question is who will be responsible for the operation? Because if we would like the contractor to be responsible for a long period of operation, our choice will be the gold book. Here is the most difficult question, and I hear a lot of wrong answers from people who do not have experience with FIDIC books. This is the question, do we have major unforeseen risks? Which means that the tenderers cannot estimate the price because they don't know what is underground. We don't have enough information. So you will not have competitive tenders, but they will just play Russian roulette because they don't know what is happening in the future. So the answer here is not to transfer too much risk to the contractor. This was said by Mr. Singh in the beginning. This is a wrong strategy. This is statistics from a book. When you go for the red book, you have, let's say, 10–15% increase of the price due to unforeseeable conditions, but this will be the range. If you have a yellow book from the beginning, probably you are going to pay 5% at least more for the design and for the risk for lump sum quantities, lump sum prices. But if you have a silver book, you have to be ready from the beginning to prepare a budget which is with 20–30% more. And imagine if there will be no risks, then this will be profit for the contractor. So the question is, do we want to spend more money for silver book contracts? Sometimes the banks want more certainty, or if we have concessions in this situation, people prefer to have full transfer of the risk to the contractor, but you have to be careful using this EPC contract. So we have, besides the standard forms, we have the guidance, we have also different guidelines, we have newsletters, we have also the trainings, we have FIDIC awards, where you have the award for project, for golden principle, and we have different types of awards that you can apply for. And you have the conferences for this topic. The conferences of the FIDIC users are very important. And all of this is part of the FIDIC body of knowledge. The process of development of a contract form is very rigorous. First of all, we select a task group, and then this task group is preparing the draft A of the contract. This draft A is reviewed and commented by the contracts committee. After that, the draft B is prepared, and then it is approved by the contracts committee and submitted to the special advisors. After their comments are taken into account, the draft C is produced, and then it has to be again reviewed by the contracts committee and comments incorporated, and then we have a process of friendly review. So this is sent to different people who have FIDIC experience, and their comments will be integrated for the production of the draft D. And then we have the process of legal review, and after that we have the draft E, which has to be finally approved by the contracts committee and prepared for publication. That's why it takes years. So you can see here the contracts committee, and on all meetings we have someone from the board. The primary liaison is Catherine from Canada, who is actually the first lady president-elect of FIDIC. So after 110 years, we shall have this year a lady who will be a FIDIC president. And we have Sarvono from Indonesia, who is the secondary board liaison, who is also attending our meetings. And the secretariat is also helping for the contracts a lot. We have the Duna, who is the head of the legal and compliance, and Yeva, who is responsible for the bookshop and for the international clients. And of course, Nelson is the machine behind all of this, who is the manager of FIDIC. We have this small group of special advisors and legal advisors, and now at the moment FIDIC has opened a call for legal advisory board. So anyone who knows very well FIDIC provisions may apply for being part of this legal advisory board. And here you can see two esteemed experts from India who are working in the groups I'm responsible for. So I have selected these people from a big group of volunteers, and they are very good, and I'm very proud of them being with us. So the goal is to have volunteers from different parts of the world and to have their input, and you can always apply if you feel that you are ready to do this. We have a lot in the pipeline. So for example, TG9, Vijay is part of this one. We are preparing 6 new subcontracts. Also, there is another group preparing a guide for the Emerald book. Bronze book is almost ready, probably to be published this year. And now we have new groups, which is for offshore wind farm, which is just starting. Another one for PPP, which is starting. And the collaborative contracting group is in the middle of its work. Also, FIDIC is preparing a handbook for practitioners and a JV agreement for contractors, and there will be update of the procurement guide, a new EPCM contract. And next week, we are starting a new initiative, which will be for preparation of net zero emissions guidance, where we have also Indian representative. The webinars are available on the FIDIC website. You can now register for the webinar on the inflation. We have prepared guidance, which will be published probably one day before the webinar. And you can watch recordings from any previous webinar. They are free on the FIDIC website. There are a lot of newsletters with information. If you are interested to be certified as a contract manager or a trainer or adjudicator, you can go to the FCL site and apply there. First of all, you apply with documents, and then you go through different exams. And you can go to the Climate Change Charter to unite your efforts with FIDIC, because this is very important for all of us. There are a lot of state-of-the-world reports, which are also freely downloadable. You can go to the relevant section, and you can see different initiatives which are under the new brand FIDIC for Global Goals. This is a screenshot of the FIDIC website. You can see that now we are preparing for May conference, which will be online, which will be for Europe, Middle East, and Asia, Africa, sorry. Then you can also register for the other face-to-face conferences, which are going to be in September and in the end of the year. So you can be in contact with FIDIC, you can volunteer for any of the task groups and follow up what is happening on the website. Thanks.
Thank you very much, Rihanna, for the very many books that FIDIC suite and of varying colors. And I think it was especially interesting to hear about the people that are behind these books, especially the people in the teams that have worked towards creating these books and building on them. I think one thing that I picked up on is you said, of course, and I'm sure all of us would agree and audience would agree, the red, yellow, and silver books are certainly very popular and definitely so in India, disproportionately to the other books. I said very nicely that they're quite similar, but there's one thing different about them, the risk allocation. And you took us briefly through how the risk of the silver book. In this context, Jenny, would you please take us a little further into how this risk allocation plays out from the red to the yellow to the silver?
Yes, certainly. Well, thank you everybody for having me today. And thank you for the kind introduction. I specialise in construction, infrastructure and energy disputes. My practice is a mix of domestic and international arbitration, and in the international context, usually disputes in the Middle East, Africa and Asia. And those international arbitration disputes typically have a FIDIC contract of some form at their heart. I say some form because personally I have never seen an unamended FIDIC form in practice, and maybe that reflects the fact that I have a disputes-based practice, as others I'm sure on this call will want to talk to. However, those disputes normally start with some form of red, yellow or silver book at their heart, often amended to suit the stronger party, typically the employer. Paul's going to talk more about the amendments. And today, I'm going to talk about, firstly, what do we mean by risk allocation? Then move on to broadly, what is the nature of the risk allocation in the 99 red, yellow and silver books? And I'm going to focus on those because, in my experience, they are the most commonly used. And I understand that in particular, they're of interest to the Indian market. Then I'm going to briefly mention the FIDIC Golden Principles and Golden Principle 3. And then I'm going to move on to consider specifically how the red, yellow and silver books deal with risk in relation to design obligations and payment. So moving on, what do I mean by risk? Risk is a broad term which might be a reference in this context to a number of concepts. We might be talking about the allocation of obligations. So for example, who's going to be designing the works, and who bears the risk if there's something wrong with that design. We might be talking about a conferral of rights. So when is the contractor entitled to additional payment, or when is the employer entitled to terminate the contract? That can also be bounded up as a kind of risk. And finally, we might be talking about risk events. So normally these are events which might be separate to the parties or under the control of one of the parties, which have the propensity to add time or cost to the works. So for example, unforeseen ground conditions or adverse weather events. I'm going to try and cover some of these today through the lens of the three books, but others are going to delve deeper in the sessions which follow in the next few months. On this slide, I've added a reference to a report by Sir Michael Latham. It's quite old now, 94. But it's a really useful in-depth review of procurement and contractual arrangements in the UK construction industry, much of which is also relevant to the international market. And the report recognised that construction risk is inherent. However, it can be, and these are Sir Michael's words, managed, minimised, shared, transferred or accepted. So in broad terms, that means that a party, not normally the employer, needs to weigh up the cost, time and control that they want to have and select appropriate contractual terms which best fit that balancing exercise. Unfortunately, you can't have it all. But the FIDIC contracts provide various options to indeed manage, minimise, share, transfer or accept risk. The FIDIC contracts offer various different risk models, which I'm going to come to in a moment. But broadly, I think it's useful to start by considering the risk principles which underlie the FIDIC forms. And primarily, that is, a party is to bear risk if that risk is in their control, if that risk can be transferred by insurance and then recover the premium as part of the contract price, if a party has the economic benefit to the risk, or if it's considered efficient that they should so bear it. So with that, let's see what the forms themselves say. So starting with the 99 Red Book, and this is the first edition of it, it describes itself as set out on the slide. So an employer-led design, perhaps with a very small amount of contractor design. And broadly, the Red and the Yellow Book, which I'm going to come to, allocate risk sharing on the basis that it is the contractor who takes construction and other risks which it can reasonably estimate. And it's the employer that takes the risk of unforeseen and other conditions which cannot be readily ascertained in advance by the contractor. And the theory is that this is fair and ultimately leads to a lower contract price because the contractor is not putting a premium on risks that it can't reasonably estimate but would otherwise have to bear.
Janie, can I just say one word that
Yes,
somehow you are not audible to us properly. Can you do something about it, please?
Oh gosh.
Can you come closer to the mic or do something about it? Or
yes, I'll lean forward. Is that any better?
Yeah, it is. It is.
Yeah. It is feeble. We are able to hear, but it is a little feeble. Maybe you can talk a little louder or come closer to the mic.
Yes, I'm sorry. I haven't had this problem before. I'll talk loudly as if I'm in a theatre or something.
That's better.
So moving on then to the Yellow Book. Hopefully that's better. This is how the Yellow Book describes it itself. It's more of a classic form of design and build contract. And the differences between the Red and Yellow Books, we'll get into the detail in a minute, but the differences can broadly be explained by the amount of contractor design and so the associated ascertainable risks. In broad terms then, the Silver Book, it's materially different to the Red and Yellow Books. It was the new form introduced in '99 and in part designed to address employer amendments that were very common in relation to the previous editions of the Red and the Yellow Books that had attempted to shift risk or obligations away from the contractor to the contractor due to inflexible budget constraints and the like. It was also designed to suit projects where there was no traditional engineer as such. In construction law projects in a common law Anglo-Saxon jurisdiction, the role of the engineer is very familiar, to me at least, but in other regions of the world, not so much. And so rather than tinker with the Red and Yellow Books, which had previously been done to suit that scenario, the Silver Book assumes that there is no such person and adopts an entirely new structure. The Silver Book envisages that a tenderer is permitted to verify the information in the employer's requirements and carry out necessary investigations very early on. So if you adopt a Silver Book, you're likely to have a much longer tender period to enable the contractor to ascertain those risks. The Silver Book gives the contractor a lot of freedom to carry out the work in their chosen manner, provided it meets the performance criteria specified by the employer. And the employer in return is given some comfort by lengthy tests on completion. As we're going to see in a moment, the contractor under a Silver Book carries a lot of risk, design, errors in the employer's requirements, etc. But in return for carrying that risk, usually the contractor receives a higher contract price, and Adriana had a really useful slide on this earlier. And in return, the employer has the benefit of greater certainty. So with that brief introduction to each of the forms, I'm going to briefly consider the golden principles, and I know Paul's going into more detail on this. But just on the topic of risk, the intention of risk allocation in the FIDIC contracts as drafted under the red and yellow books, where you have the general conditions, they're said to be based on a fair and equitable risk allocation between the employer and the contractor. And in this context, I say said to be, because some might say that the contracts are still fairly employer friendly, but I think that's a talk for another day. And in terms of the intention of risk allocation in a silver book, the intention is to give the employer greater price certainty, as I've already alluded to. And so reflecting those intentions and in an attempt to protect them, the FIDIC drafting committee has come up with what are called their golden principles, and they are intended to be a statement of best practice. The second editions recommend that drafters of the particular conditions adhere to these principles, and in the context of risk is golden principle 3. The particular conditions must not change the balance of risk reward allocation provided for in the general conditions. So this is the intention of the FIDIC drafters behind their forms. And you can see a very similar point is made in the foreword to the red, silver and yellow books, which I've set out on the slide. And that's the theory. But the particular conditions can, and in my experience as someone who sees the disputes at the other end of it, typically do alter the risk allocation in favour of the stronger party. So with that introduction, let's delve into the detail. Firstly, design obligations. So firstly, the basic design obligation in the red book is that the design is primarily carried out by or on behalf of the employer, save for in limited respects. And the employer can identify limited elements of the design the contractor is required to develop and complete, and then set out its requirements in the specifications and drawings. The yellow and silver books are materially similar. They're both forms of design and build contract. The employer sets out their requirements in the employer's requirements, and the contractor completes the design and is responsible for it. That design must be in accordance with applicable laws, technical standards and the like, and the contractor carries the risk that those laws and standards might change right up to the base date. So that might be after the tender goes in. Still on the subject of design, fit for purpose obligations. In all books, the contractor is responsible for ensuring the design that they carry out, so that there might be a limited amount of design under a red book contract. So the design the contractor carries out is fit for purpose. And in the in the yellow and silver books, that purpose is set by the employer in the employer's requirements. So still on design, what about errors in the specification or the employer's requirements drafted by the employer? Generally, in a red book scenario, the contractor is not responsible for the errors. And that makes sense because the employer is usually designing the works. In a yellow book, the risk is carved up. So the contractor is required to scrutinise the employer's requirements on commencement and within a specified time. If the contractor discovers an error in that time and gives prompt notice, the contractor may be entitled to additional time or money as a consequence of correcting that error. But if the contractor fails to spot the error and should have done, so an experienced contractor in their position would have done, or fails to give notice in time, so there's a procedural element to it, it's tough luck under the yellow book. The contractor bears the time and cost risk of that error. In relation to the silver book, again, the risk is carved up. The contractor is expected to scrutinise the employer's requirements, but this time prior to the base date. So I've mentioned earlier, there's a much longer tender period. And even following such scrutiny or deemed scrutiny, what they ought to have done, the employer is only responsible for the time or cost consequences of a very limited and defined list of errors, which are set out on the slide there, clause 5.1. So under a silver book, the contractor carries a much greater design risk than the other two. Finally, under design then, what about the risk of delayed design? Under a red book scenario, as the employer is designing, generally the employer takes the risk. But I've just flagged there on the slide, the contractor needs to give 2 notices. So there are procedural hoops that the contractor needs to jump through in order to make its claim out. And I know others in other sessions are going to talk about how the Indian market might treat those kinds of obligations and the effect on the contract. Under a yellow book scenario, as the contractor's designing, generally the contractor takes the risk of delays to that design. I mean, that makes sense, that's fair. There's possibly some scope for a time or cost claim as a result of delayed design approval. And I've seen many such claims in arbitration. But just to note here, the contract includes a deeming provision in relation to such approval. So such claims are quite hard to make out. You generally need to look for some communication from the engineer suggesting that the contractor needs to wait beyond the 21 days deemed design review period. In relation to the silver book, again, as the contractor's designing, generally the contractor takes the risk of delay. Again, they might mount a time or cost claim as a result of a delayed design approval, but it suffers from similar difficulties as the yellow book. So hard for a contractor design delay claim to be made out. So that's a whistle-stop tour of design under the 3 books. Moving then to payment. As to price, the red book is a measure and value contract. The price is as set out in clause 14.1, which points you back to agreement or determination under clause 12.3, which is a measurement and value obligation referable to the rates or prices in the bill of quantities. I would expect, and it's common, that the bill of quantities is derived from the tender price and is used as the rates or the prices for the clause 12.3 evaluation. So the risk there sits in the bill of quantities. The yellow book is a lump sum price with little or no remeasurement, unless it's stated otherwise in the particular conditions. I've highlighted the relevant part of clause 14.1 on the slide, if the employer or contractor wishes for there to be some remeasurement. So generally under a yellow book, without that remeasurement, the contractor takes the risk of changes in cost arising from his design, including quantity changes. Silver book, again, it's a lump sum contract, but with greater employer certainty. The intention behind the silver book is that all matters that could cause a change in the price would be settled before contract signature. Again, this means that additional time needs to be allowed during the tendering procedure to enable potential contractors to assess the site and to assess the contract conditions. So still on payment, adjustments, notwithstanding what I've just said about the basic price, all 3 contracts do provide for some form of price adjustment under different circumstances. And as you can see, it's broadly similar across the 3 books as drafted. The silver book contains clause 4.12, which ends with 4.12c, which I've put in bold on the slide, which states that the contract price shall not be adjusted to take account of any unforeseen difficulties or costs. And if you read this in isolation, an employer might take quite some comfort that it's unlikely to pay more than the contract price. But it shouldn't be read according to its strict terms. As you can see on the slide, I've set out all the clauses under the contract in which there might be a price adjustment. As you can see, there's quite a long list there. So even under a silver book, there are circumstances in which the employer takes the risk of having to pay more than the initial contract price. Finally, then, I want to end on the valuation of variations and the risk of the price increase under each of the books. Under the red book, it's fairly clear how you should value a variation. You measure and value in the same way as the contract works. When you get to the yellow and silver books, and in the 99 suite in particular, there's a little bit of a gap, a little bit of a lacuna. We're told that the contractor is entitled to reasonable profit, but not whether the variation is to be valued at cost or on rates, perhaps derived from the original contract price. And there can be quite a difference, especially if the contractor agreed to a low price to obtain the work, or if the variation is instructed later on in the works and the costs have substantially risen. Of course, there's also the chance that it works the other way. The rates might work in the contractor's favour because they have seen variations coming their way and they have prepared a bill of quantities supporting the lump sum prices accordingly. So if you have a 99 yellow book or a silver book, and this point hasn't been cleared up by an amendment, I'm sure others on this will not forgive me for mentioning the need to amend, but I think this may be one limited area that you might want to consider. There's a right ground for dispute, and I see nearly all construction arbitrations based on these forms raising some dispute as to whether the variation should be under a rate or a cost valuation basis. So with that, I will end. That was my whistle stop tour through risk allocation under the three books.
Thank you very much, Jenny. I think that's a very, very significant and important topic for our audience to understand. We will now have a short break of about 10 minutes. I think we'll all appreciate that sitting through a 2.5 hour long webinar can be a bit difficult, and even more so if you have to do it continuously. So let's have a 10-minute break and be back around 7:40 p.m. India time, after which Venkat will take us through the various considerations that go into picking one of the books, right? So see you all back at 7:40. Welcome back, everyone. Um, After a short break, let me just recap very briefly where we left off. Jenny took us to the three most popular books, the red, the yellow, and the silver book, and explained in, I suppose, helpful detail how risk is allocated under various topics. Now, that prompts the question, which book which book that prompts a question as to which book an employer or contracting party should choose uh, for particular projects, and what considerations go into making that choice. With that context, I would invite Venkat to take us through these considerations and also walk us generally through what the contracts look like and how the tendering process works. Venkat, would you be happy
Yeah.
to begin? Yes.
Yeah. I'm audible?
Yes, very much.
Okay. Okay. Good evening, ladies and gentlemen. Thank you for Mr. Rajan Singh for having me in this conference. It's very interesting. And as a consultant in this part of the world, especially in the GCC region, we breathe FIDIC because most of the contracts drafted here are based on the 4th edition. They're moving to the 99. Still, we have a long way to go to the 2017 edition. So it's a good opportunity for me to explain what's happening in this part of the world and our experience using these FIDIC contracts generally. Just a minute. Yeah, that was the introduction. I'll just skip that. So in this short presentation, I would like to talk about the contracts guide, that a kind of an overview, because the time is limited. So we are doing only the introductory session today. So we would briefly touch upon that. Then apart from the color-coded books like red, yellow, silver, we have been talking all through that. FIDIC is published, as Adriana was saying in the beginning. There is a contracts guide, which is very, very helpful for the employers and the developers. What kind of a contract what kind of a form to be chosen? How do we do that? Do we go for a lump sum route, or it's a measure and value? So these kind of things have been very well explained in the contracts guide. We will see some of the principles out of that. Also, they have published procurement guidelines. That's a very, very interesting and very exhaustive book. As normally I used to say, the FIDIC is more than the contract form. This is like in a contract management manual. This is how we look at the FIDIC. So we will briefly touch upon that procurement guide also. Then the structure of the forms, when to use silver, when to use yellow, there are some guidelines available. Then for the employer who wants to prepare a contract based on the FIDIC suit, what are the important points to be remembered while preparing the tender documents? We will give a brief on that. And finally, we will discuss how these 20 clauses of the FIDIC is being nicely stacked. I know that we have already discussed about the various clauses, 14, 13, 4.1 and all. I will just put it across that how nicely it is unveiling from beginning to the end. And finally, we will take questions in the question sessions. So the FIDIC contracts guide basically is for the 99 edition. So the red, yellow, silver, these three books. When we talk about this color-coded books, actually one interesting incident comes to my mind. We had a client in UAE. Whenever we want to draft a contract and which FIDIC book we should go, she will immediately say, go for silver. So that is her choice. We used to wonder that this contract need not be on a silver book. Why the preference is always silver? Then after some time, we understood she preferred silver because she thought that silver is something like a premium. So we said that silver is only a color. It is not actually a premium. Then if you want to go for silver, probably you can go for a gold itself. In fact, we call the silver book as a gray book because in this part of the world, it has been the most misused kind of a turnkey contracts we used to have based on the silver book, passing all the risk back to the contractor. And we have n number of disputes on the silver book in this part of the world, especially. The lump sum turnkey is actually it's a nightmare for the contractors generally. So how do we go about it? Let's say that an employer wants to procure a contract, he wants to make a project. What kind of options he wants to do, how he wants to package the contract. Generally, this FIDIC Red Book contract and all suitable where the employer wants to use a single lead contractor or a main contractor with various contracts being used as a subcontracts. Sometimes the employer thinks that why should I pay profit on a profit? Why should I give a single lump sum contract to a civil contractor? Why can't I go for package contracting, introducing like the building services as a separate package, finishes as a separate package, civil works and infra works on a separate package. So how do we want to go about it? Yes, it may be a good idea if he wants to save on the profit on profit. However, he needs to do a lot of coordination work. So that's something which needs to be looked upon. The other thing is the 99 suite of contracts have been classified based on who do the design. So that's the basic idea. So there was some discussion already about that. Red Book, majority of the design by the employer with the limited specialist design passed on to the contractor. Yellow Book, contractor design, and Silver Book, again, contractor design, undertaking further risks in the contract. That's how it has been. Also, FIDIC contracts guide provide some kind of a guidance when to use a lump sum, when to use measure and value, or when to use the cost plus. So we will look at these concepts. Now, as I said, if the employer wants to package the contract into several packages, he may be able to get a competitive pricing, but he has to take a larger risk on the coordination. This is a major problem we face in this part of the world, because a lot of times we have seen the electrical package will go without any provision for the elevators, and the elevators package will have only the elevators without the associated electrical package going along with that. So that's a quite normally we see this kind of a coordination. There is a gap in the scope between the various packages. So the employer, if he wants to do that, he has to employ good consultants, good contract administrators to ensure the scope is properly mapped out and there is no gap or there is no overlap between these different packages. The other thing is, if the employer undertakes the design, he will have the greater control over the details. Like most of the time, we do a lot of changes in this part of the world. We start with a hotel project, midway it will become like a service apartments, then it will become like a residential building. And just 6 months before the completion, the client will come and ask, can we do a 50% of the tower for an office tower? So that's the kind of a change the employer wants to do. Then we would say that normally then don't go for an yellow book or a silver book. Better do you go with a red book, because you have an engineer, you can issue the revised IFC drawings. You can ask for that to be priced under the class 13 variation. So he would be able to manage well the changes in the design. Similarly, whenever we have a lot of experience in using the yellow book and the design and build in this part of the world. In fact, it was a disastrous start, I would say, when we did a Bank of Bahrain in Bahrain. The contract, the first time we were going for a design and build contract, the employer was not trusting the contractor's design. So everything he wanted to be rechecked, peer reviewed. Some of the errors were found. So then there was no trust at all on the contractor's design. So throughout the contract, there were a lot of arguments between the contractor and the employer. And no wonder the project was delayed and it went to arbitration, and we had all the kind of problems in the end. So the employer need to understand, if at all the design is given to the contractor, he would develop the design. Of course, he will have that fit for purpose obligations, but he would do the design which would just comply to the requirement, nothing more than that. So if at all any fancy design or any kind of over the design aesthetics are required, perhaps it may not be a good idea to go for a design and build route. Rather, the red book would be the ideal one for the contractor, for the employer. The other thing is, the red book, again, the employer would have the design responsibility. If at all some of the portions to be designed by the contractor, they need to identify the portion of the work and the design criteria to be provided for that. This is something which is normally missing in this part of the world. 4.1, it says that in the bracket, to that extent specified in the contract, but we would normally see nothing would be specified that what would be the contractor's design. So then there will be a lot of argument. The employer would say that this is part of the contractor. The contractor would say that there is no design criteria has been given. Then the discussion comes about, you are an experienced contractor, you should know what is required for me. So all these kind of arguments generally happens. So that's why we normally say, if at all you need to keep some of the design, for example, post-tension slab or steel structures, staircases. So these kind of things are never designed by the employer or employer's consultants. These are all left to the specialist consultants to do. So they need to provide the criteria based on which the contractor would be able to price it and do the job. Also, if the most of the works are to be designed by the contractor, so then it is not going to be a red book. It's not appropriate to have a red book in that case. So basically, it's like a sliding scale that if that's very minute amount of design to be done, then the red book is fine. Then the scale is going more of the design to be undertaken by the contractor, then it has to be in a yellow book without any question. Similarly, how to compensate the contractor? See, a lot of times we see, at least in this part of the world in Dubai, before the design is fully complete, they would be rushing to the tender. So a lot of times, if you go for a lump sum, there are two risks actually here. One is the contractor will not have the complete design, so he has to make a lot of risk allowances. So the employer end up paying a very high price because of that. Or alternately, the contractor may not have priced correctly because the design is incomplete. He might have priced based on what is given in the tender drawings. Then when the revised drawings are issued or the final drawings are issued with the complete design, the contractor will come and say, no, that's not included in my price. I need to be having a variation for that. So that's why it is, it's normally the recommendation is if the design is incomplete at the time of tender. Also, I will add it here. If the quantities cannot be estimated precisely, like for example, infrastructure works, road works, bridge works. So those kind of things, we don't know what are the chartered services below the ground, what kind of earthworks would be involved. So there it is normally it's preferable to have a remeasure. And in fact, the FIDIC Red Book, in my understanding, it is actually a measure and value contract only. Later on, the lump sum, it has become a very popular in the construction industry. So the lump sum is recommended only if the design is complete and that when the tenders are invited. I go one step more than that. The design is complete and we got all the statutory approvals from all the authorities, because the consultants, they complete the design. When they take it to the authorities, there could be some changes happening. If it is happening within the tender period, yes, amendments can be issued, tender addendums can be issued. But if the approvals are coming after the contract is awarded, then definitely there has to be some variation orders to be issued. The other thing is when we have some urgent work and the scope cannot be very certain, then the cost plus is the most recommended. So normally when we say cost plus, the employees are not very happy about that. It's like giving a open checkbook to the contractor. They believe that the contractor would be taking them for a ride. In fact, we have done Doha Sheraton when it was to be ready within 6 months for an GCC council meeting. So we didn't have time to prepare the tender documents and it was a running hotel. Except structure, everything have to be changed. The facade and the structure was the only two elements left in the hotel. Everything else was changed. It was more than 100 million dinars worth of a contract. So we convinced the employer and we went for a cost plus pricing and it was done within the time. Of course, it was not within the budget because the budget was exceeded because of the limitations and the changes what is needed. But we had a very good audit procedures, and we had from the day one, everything was agreed that how the cost plus will be worked out, what would be included, what would be excluded, when the contractor can bring the materials from through an air freight. Everything was discussed. So the idea is, with a good management control, cost plus contracts can be managed very well, and the employers need not be afraid that it is going to be a problem for them managing that. As far as the design build is concerned, so this is something to be accepted. If a contractor is responsible for that, he would economize in terms of cost. So he would do that. It may be at the expense of quality from the eyes of the employer. That's why we have the fit for purpose obligation on the contractor. So he need to do the design for the purpose which is intended or mentioned in the contract. Other than that, as long as he is able to manage that, the employer cannot expect any kind of a better quality than the base quality. Also, in the yellow book, if the employer wants to go for that, he has to have services of expert technical consultants to review the tender requirements or even the contractor's design. So normally it is expected that the engineer would be still administering the contract in the yellow book, as we saw that earlier. Only in the silver book, there will not be any service of an engineer that would be performed by the employer himself. So when it comes to variation, this is where the major problem comes in the yellow book as far as our experience is concerned. Because there will be a consultant supervising the project, he will be the engineer, contract administrator of the contract. So whenever there is a design change happening, immediately he thinks that he has to issue the revised drawings. So he would go and issue the revised IFC drawings. Then the contractor would come and argue, look, this is my design. If you're going to issue the design drawings to me, are you absolving us from the design liabilities? Or how do you want us to go about it? So that's why in a yellow book contract, if there are any changes happening, it has to be given as a varied requirements. The contractor have to be asked to provide a varied design. Then it has to be priced, and the amendments or the variation orders to be provided to the contractor. So normally it is recommended that the cost and consequences of this variation should be agreed in advance to minimize disputes, but it rarely happens in the construction industry from our experience. So the advantage as far as the design build is concerned, it's a lump sum pricing. Undivided liability, that's a major benefit for the employer, because the design and construction both are being done by the contractor. So if there is any problem happening, it's not that he need to run after the design consultants for the design liabilities or design errors, or to the construction contractor for the liabilities in the poor quality or the poor construction of the contract. More than that, the time and cost saving, and because that there is an overlap in the design and construction, that this is what it is normally. In the conventional approach, the design have to be complete, then the tender have to go, then the construction period would start. Whereas in the design build, the design would be very minimal. It will be done, the employer requirements would be drafted, then the tender would be issued. So as long as the design is continuing, the contractor is not going to wait for the entire design to be complete before he starts his construction. If the substructure design is ready, there is nothing stopping him to continue with the construction of the substructure when the superstructure is being designed at that part. So our experience mostly, if I say that in UAE particularly, all the substations, district cooling plants, any kind of a power plants, invariably it has become like an yellow book contract, because there is not big of a design. It's like a concrete box for you to encompass all the equipments. So there is no point to having a traditional conventional approach that incorporating a design and bringing in a design engineer and again going for the tender. So those kind of contracts are going straight away to the yellow book contracts. So I would say that the yellow book has been quite successfully used in this part of the world, because the market understands, the contractor understands, and the employer also is happy with that kind of an approach. Moving on, FIDIC recommends to do a pre-qualification for the major contracts, because it would be helpful for the employer to know, to bring the level playing field for the tenderers. If it is not happening, then if you are bringing contractors without pre-qualification, a small-time contractor with an international contractor, the prices are not going to be equal. So you will have a problem in Are we going to take the L1 and we're going to with a smaller contractor? Is he capable of doing the work? So wherever this pre-qualification process was taken and then the tender went, we have seen a good success rate with less disputes of the projects. So wherever the employer wants to bypass this route and try to do straight away the tender, then he was eager to take the L1 contractor and award the contract without seeing their capabilities. A lot of times it happens. In fact, if contractor is good at in one area of construction, it doesn't make them suitable for the other area. I'll give a classic example. When we were doing a aircraft maintenance facility in Align, they want to go with a contractor who was a very big contractor in doing buildings in Abu Dhabi. So when we were trying to tell that this contractor is not having much of experience in doing industrial buildings, they said that they are a bigger contractor. They're a Class A contractor. They have done so much. Their order book is so big. What's wrong in having them to do the industrial building? But again, since they were not experienced and it was a design build route, a lot of complicated design was there. Finally, the project went to delays and disputes, whatnot. So it's always, we recommend to choose the contractors according to the requirements of the contract and what is the kind of a work. Do they have experience? Do they have a previous experience in other part? At least even if they don't have the experience within the country, have they done any kind of similar work in other part of the world? So that's very important for them to bring to the table. The other thing is, a lot of times the contractors may want to go for a joint ventures. That's quite common these days. So the employer can be aware about this joint ventures, who are all the partners in the tender going to be. So he can review and he can vet and he can make sure. So once the pre-qualification is done, then after that the tenders are given, and when the prices come, it is not going to matter for the contractor, for the employer, whether it's going to be X or Y, because all are on same par. It doesn't matter. He's going to get the kind of a quality, at least in theory, that any one of them going to undertake the work. So that's about basically very briefly the procurement guidelines and the contract guidelines. So now I would move on to the structure. So there are 20 clauses in the contract. Before that, we have discussed about this general conditions and the conditions of particular application. This is how normally the FIDIC contracts are made. The recommendation is we should never touch the general conditions. It should be left as it is. The particular conditions should be addressing some of the things which are all definitely required to be changed. Of course, we have to have a particular application because we can't just take the general conditions and go for the tender, because a lot of things have to be done. For example, the dispute resolution, what is the forum, the jurisdiction, what is the law of the contract. So a lot of things need to be done. So the particular application is very important. The only thing what we normally tell the employer is the less is more. If you've chosen to do the FIDIC contract, the minimal amendments you do in the particular application, it is good for you because contractors understand their risk. So they would be able to price it correctly and you would be able to get a good value for money as far as this is concerned. So that's a particular conditions. So in this part of the world, we used to have a clause called the boycott of Israel. I think it is not there anymore. Then we have some civil code guidelines, Dyson liability. There are some special clauses would be there as far as the local laws are concerned. Sometimes specific damages related to performance. These are all the things have to be incorporated in the particular conditions. So the golden rule, as I said, is retain the general conditions as it is and amend only the particular conditions rather than rewriting the entire FIDIC contract as part of the general conditions all over again, which is not normally recommended or required. So this is appendix to the tender. All the numbers and the days, all these things would be nicely brought up into this. So the general conditions, particular conditions, appendix to the tender, three together would be the contract. So that's how normally the FIDIC 99 suite of contracts are all awarded. So normally the tender documents are prepared by engineers. I think it's a small E, not a capital E here. This is I'm talking about the professional engineers. This is what FIDIC says. And it has to be reviewed by suitably qualified lawyers. Of course, it's very important to have the precision of your language and other things. But generally, it starts with, as you see, the FIDIC is actually the Global Federation of Consulting Engineers. So basically, the professional engineers have been given the responsibility to draft these contracts. So the tender documents, as I said, the conditions, specification, drawings, A lot of things are there. There are multiple authors preparing the tender documents. Definitely, it's a long process. So what we would include for the specification and drawings for the general Red Book contracts, employer requirements. Sometimes you may have drawings. If it is in a turnkey contracts, we used to call it a FEED, front-end engineering design, FEED drawing, FEED information, or sometimes we call it just an employee's requirements. The important thing is the hydrological and subsurface conditions of the site, any environmental impact study, traffic study, all these reports have to be provided by the employer as part of the tender documents, although he doesn't take any responsibility for the correctness of that. So this we would like to emphasize, because there are cases we have seen these documents were not provided. Later on, there were some disputes. So it was argued, and of course, the case was lost for the employer because it was considered as a misrepresentation of the facts. So the contractor spent extra money because of the soil conditions and the rock. So the data were available with the employer. It was not given to the contractor. So there was some issues with that. So tendering procedures, of course, I'm exceeding time. I will just rush through that. The one important point here is whenever there is a design build, if the contractor is doing a design and he is quoting the price based on that, the employer may like the design of one particular contractor, but he may like the price of the other contractor. The employer should not use the design of another contractor and use it for his project without taking permission, because the contractor hold the rights for the design. So that has to be something which need to be very important for the employer to remember that. The other thing is the various phrases like up to the date technology, state of art technology, those kind of things should be avoided. It has to be unambiguous terms. The obligation should be stated. That's the way it is normally recommended. So the employer and the contractor and the engineer, there are three parties in the contract, but there is no contractual relationship between the engineer and the contractor. That's why we call the FIDIC as a tri-party bilateral contract. So employer and contractor would be on a Red Book contract or an Yellow Book contract, whereas the employer and the engineer would be on a White Book model services agreement, separate contract. So I will just take 2 minutes. I think I'm exceeding my time. So the FIDIC 99 or even the other two books have 20 classes totally. So how they are stacked, that's what we would just give an overview of that. That would be closing my presentation. The general class 1 is the general provision, definitions would be there. 2 to 4 would deal with the rights and duties and obligations of the three parties which we have mentioned: employer, engineer, and the contractor. So that's how it is. Then class 5 to 7 will discuss with the resource elements like nominated subcontractors, staff and labor, plant, materials, and workmanship. The 5 to 7, they deal with that. Then normally we talk about the time cost quality triangle whenever we discuss about the construction project management. So the time and cost elements have been discussed here actually. Class 8 to 10 deal with the time aspects of the contract, commencement, delays, and test on completion, taking over in sections. These would come under that. Of course, the quality, it is discussed in the workmanship, but the defects liability period would be discussed under the class 11. 12 to 14 is normally discussed the cost elements or the monetary elements of the contract, measurement and valuation, then the variations under the class 13, then the contract price and the payment, how it is going to be, that would be discussed under the 12 to 14. 15 and 16 would discuss with the termination. One is by the employer. For the contractor, it is a two-stage process. He does suspension, then he will do the termination. That's how it would be normally done. 17 to 19 deal with the risk, insurance, force majeure. This is normally indemnities. These things, the commercial elements of the contract and the risk elements of the contract would be discussed under 17 to 19. Class 20 deals with the claims and disputes. Of course, in 2017 edition, we have one more class because the claims and disputes have been bifurcated. Class 20 deals with the claims and 21 deals with the disputes. This is how it is stacked in the 2017 edition. So these are all the variations like class 3, 5, and 12 in the yellow and silver books. There are some different things because the design is not by the employer. So that's how it is. So these things I will just pass on because I've taken a lot of time. So thank you very much. I would give the floor back to Jaytan for the next session.
Thank you
I
very
apologize
much.
for taking extra time.
Sorry?
I apologize for taking extra time.
No, I don't think you did. I think we're good. And thank you for, of course, taking us through a very important aspect of all of this, how these models ultimately are put into practice through tendering, procurement, the considerations that go into that sort of thing. I think that is very helpful and very useful for our audience. Now we move to a particularly interesting area of dealing with FIDIC contracts, and I'd just like to recall to something that Jenny said. Jenny mentioned that she hasn't ever seen a FIDIC contract that was unamended, and that's what Paul is going to talk about, how FIDIC contracts are amended, what the common amendments are, and as you will see from the cover of the slide, somewhat controversially, how FIDIC contracts can be misused. Paul, would you please tell us about common amendments to the FIDIC contracts and how they are sometimes misused?
Thank you. Firstly, I'd like to thank the SCL-India for inviting me to participate, and also Mr. Singh, because I think your opening addressed everything I'm going to say. I could sit back and do nothing now, and I think they've heard it all. And I would like to add that I think I joined the club that I've never seen an unamended FIDIC contract. So we're all in the same boat in terms of that respect. But before I talk about a few amendments that I've seen typically, just let me recap a few things. We can see from the early pages of the 1999 suite just who was the drafters. Adriana noted the names and so on of the current sets of drafters and the various drafting committees. But for this version, excuse me, I have a terrible cough. For this version, we had what was known as the Update Task Group. For those of you who don't know, prior to 1999, there were very, very many FIDIC contracts, but they weren't grouped like this one. As Venkat said, there is a grouping such that all the contracts look very similar, the 20 standard clauses with minor exceptions and so on. So this was called an update, although it was really a complete revision of the FIDIC suites. So the Update Task Group was 4 engineers, engineers from Europe, UK, and Latin America. The one lawyer who seemed to have been around forever, who was mentioned by Adriana as well, Christopher Sapella. In my book, he is Mr. FIDIC. He is the guru to which everyone should try to get to listen to at some stage in their career. Now, they were directed by a contracts committee, similar to what we have today. Again, 3 engineers, one from Europe and from the UK, and a special advisor. Now, the special advisor was also an engineer. You may get a theme coming through here of engineers being very prevalent in the drafting. Following the drafting, there was reviewers, as was seen before, again, mostly engineers, and a number of lawyers looking at the legality, the enforcement, the obligations, and so on of the clauses. And then quite sensibly, very sensibly, was the lending agencies. A number of lending agencies were also asked to review the forms. You must remember that at the 1999 edition, there was no pink book. That came later. The MDB pink book came later. So the lending agencies were looking at what was there to see if they could use this FIDIC suite. And we now know that FIDIC currently have agreements with many, many lending agencies around the world, such that FIDIC is very, very popular. Insurers. Insurers were, or insurance brokers or insurance companies were asked to look at clause 18 to see if the risk allocation there was insurable or not insurable, such that they had a very valid input. And then finally, contracting organizations. The most prevalent of those being the European international contractors, which I'll come on to with my next slide. They look after, or they are a group of civil engineering and building contractors. Orgalim, which is a group of mostly industrial contractors, and they would have looked at the yellow and silver book, because I think what we all understand is predominantly, and I would use the word predominantly, the red book is for civil engineering, because it's mostly where employers will design the works, and the yellow and silver books are design and build, when perhaps the employer's requirements will then be fulfilled by the contractors. And the Association of Dredging Contractors had a very, very early look-see. So let's talk a little bit about the EIC, the European International Contractors Group. It's a little bit similar to FIDIC in that it's a grouping of national societies of contractors or associations of contractors around Europe. These contracting organizations represent Denmark, Germany, Italy, France, and so on. Strangely enough, UK is not represented. We don't seem to have any more international contractors of note, or enough international contractors to have an association. So they have, over the years, created some guidebooks, if you want to call them, on the background that FIDIC says that the contracts are fair and balanced, and there is a risk-reward allocation between the employer and the contractor. The EIC sort of comments from the contractor's viewpoint, and it's definitely worth a read for all of those who will be preparing particular conditions and wish to seek a contractor's input as what will be a balanced contract. The EIC doesn't hold back. It often criticizes some of the clauses within FIDIC, and I would have to say it's constructive criticism. I come from a contracting background, and therefore I perhaps understand what they're saying a little bit more than perhaps some of the engineers that have drafted the books. Some of their criticisms, I'll make one or two notes. The 8.1, clause 8.1 notice to commence is only 7 days. This is almost starting the clock ticking for the period for the time for completion. And now they're saying, well, hold on, we're coming from a foreign country, we're coming into a different country. That might be a little bit onerous for having the clock starting. So they would perhaps see a 28-day period as being much better. Now, also in respect of claims entitlements, FIDIC has this cost or cost plus profit. So in some claims clauses, or where a contractor can get a monetary entitlement, there is only cost, and some there is cost plus profit. This will be dealt with, no doubt, in our later sessions. However, the EIC say, well, we don't understand this. We don't understand this logic. And I must admit, I don't understand the logic. For me, that being a contractor's man, if anything that was worth doing and worth carrying out and paying for by the employer, then it should attract profit. It's turnover. It's turnover for a contractor. If that work element was included in the tender, then it would attract profit as decreed necessary by the contractor. An example of that, I think, is perhaps claims under 412, unforeseeable physical conditions in the red and yellow books, being a cost only, which can be a significant amount of money change in terms of the contract price with a substantial ground conditions claim. And the EIC also comments that the periods between suspension and termination relative to subclause 2.4, employers' financial arrangements, and also subclause 14.7, the period for payment, the period between suspension and termination is too long. In this respect, I think the EIC respect that cash flow is the lifeblood of the contracting industry, a famous quote by Lord Denning, and they look to see the financial security of their members, the contractors, is upheld by any particular conditions. And they think that maybe FIDIC in their general conditions have just made those periods too long. There's an immense risk for the contractor. In fact, if you think of what the risks are for a contractor in global terms, there is its performance as defined by the contract, whichever version that is, and then being paid for that performance. And all contractors would like to see quicker payment than perhaps is in the FIDIC books or any other contractor for that matter. So these books provide advice for anyone who's going to draft the particular conditions. The books are now widely accepted by FIDIC, and you can actually purchase them on the FIDIC book site, website. Okay, so why amend a contract? FIDIC says that standardizing both in technical and administrative matters is desirable for the satisfactory execution of many types of commercial projects. I fully agree with that, and I'm sure that most of you in the audience will fully agree with that, if not all of you. I'm sure the panel would agree. Many projects are complex. It is becoming increasingly important for them to be based upon a standardized form of contract with which the contracting parties and the financial institutions are familiar. We've mentioned lending agencies quite a few times. Lending agencies really require certainty. Perhaps that was one of the biggest drivers of the Silver Book, the certainty that the lump sum fixed price subject to amendment as per the contract can provide the lending agencies. Lending agencies are very often involved in Red Book, development banks looking to put roads into infrastructures into a country or whatever. So this certainty is very much desirous by those involved. And I use the word certainty a lot in my talks. Certainty of outcome for scope, time, and price is assisted, I believe, by the use of standard forms. But again, we've all seen that none of us have actually seen a standard FIDIC in real life. Why amend? Again, FIDIC concludes that with their matching set, the standard forms lessen the likelihood of unsatisfactory performance. They lessen the likelihood of increased costs for unjust reasons, perhaps, and they lessen the likelihood of disputes because of this understanding, this certainty. As has been suggested before, financial provisions, I think they FIDIC mean by that cost allowances in the tender price, are not necessary for unfamiliar contract conditions. For those of you that have ever sat on a tender board or be involved within a contracting organization at the time of tender, there will be a scrutiny of the contract conditions, and the risks within those contract conditions will be priced. Whether or not that price actually goes forward into the final bid is another thing for the tender adjudication board. But those unfamiliar conditions will have a price, and they will be taken into consideration. FIDIC, as Adriana says, is a magnificent body for training. So the training that FIDIC gives has to be, by definition, on the basic books. So everybody can understand what is necessary, what is required by the obligations for both parties within the standard books. However, if we're going to see vastly amended, ever-changing contractual conditions, then the training becomes less and less beneficial. It's quite a sad situation, perhaps. We've touched on the golden principles. Although they were first issued in 2019, as Adriana said, the principles were back to the day one of FIDIC. And FIDIC has grown. FIDIC has grown as a commercial and recognizable body that has a value to both employer and contractor. At tender stage, if an employer decides to issue a contract based upon a FIDIC book, contractors will say, great, this I understand. If it's on a bespoke form of contract, by alternative, oh, well, I'm not too worried about working for that one because I don't understand what is lurking in the conditions. Are the conditions well drafted? Are they linked up together? Sorry, someone's ringing my phone at home. My partner will pick that up. So at tender stage, FIDIC has a great value. It is understood. And throughout the construction phase, the fewer amendments to a FIDIC contract, the more understanding and certainties both parties will have in administering the contract. As we look back, although it was predominantly drafted by engineers, it was drafted with a joined up purpose. The clauses interlink, the clauses join up such that everyone can understand what is going on. And obviously throughout the defects notification period after completion. So whilst the ethos was there, and if you read between the lines, the ethos was definitely there, why was it necessary to draft the golden principles? Well, as we've seen and discussed perhaps, FIDIC badge contracts were being so heavily mended that it did not represent the principles or the FIDIC brand. So there was a movement to try and get the FIDIC brand back into the arena for what it was intended to be. Those that use the word FIDIC should adhere to the golden principles. Now, I won't necessarily read, or maybe I should. Golden principle number 1, the duties, rights, obligations, roles, and responsibilities of all the contract participants must be generally as implied in the general conditions and the appropriate requirements to the project. Don't go changing the obligations of the engineer or the duties of the engineer or whatever. The same with the contractor. Golden principle 2, the particular conditions must be drafted clearly and unambiguously. Certainty can be achieved by clarity of contract. Golden principle 3, as Jenny mentioned, the particular conditions must not change the balance of risk, reward, allocation provided within the general conditions. Number 4, all time periods specified in the contract for contract participants to perform their obligations must be of reasonable duration. I'll come on to that one in a minute when I talk about amendments. Number 5, unless there is a conflict with the governing law of the contract, all formal disputes must I say, be referred to a dispute avoidance adjudication board, that is the term within the 2017 editions, or a dispute adjudication board, the term with the 1999 editions, if applicable, for provisionally binding decisions as a condition precedent to arbitration. They just confirm the mindsets of the drafters of the 1999 edition and most likely the previous editions before 1999. So, the motivation to amend. As I've said, there's a theme at the beginning where the majority of the drafters were engineers. Engineers are employed by employers, so you would hope that the engineers who were in the drafting committee had in their mind what their employers wanted, to see. So we have employers and engineers represented very strongly on the drafting committee. But then the cynic in me says, well, come on, let's think who does make the amendments? It's the employers and the engineers. Now, we've heard before, the golden principles note, no party shall take undue advantage of its bargaining power. Now, I have to say to myself, well, do contractors want serious amendments to the particular conditions, serious amendments to the general conditions via particular conditions that make things more unfavorable for them? And I must admit, I have to say to myself, no, it's not the contractors that are looking to make onerous conditions within a contract badged as being a FIDIC. So it must be the employer trying to take advantage during the tender phase, during the pricing stage, by the amendments that it's instigated alongside its engineer. Now, Adriana noted the potential price increases between the yellow and the silver book. I have worked with a contractor when I asked them the direct question of, well, if you have the same employer's requirements, yellow book, silver book, what's your price increase? And they actually said, none. We take that risk on ourselves because we hope that we will perform well. We hope that our design will be good. Our design can be commented upon by the employer in terms of clause 5.2, and that we will perform. So they see no price increase. And I would suggest sometimes that contractors that are hungry for work do not price onerous conditions. They will take the transfer of risk, if that's what it is, that's made by the amendments, and they'll say, let's just perform, let's just hope that risk never manifests itself, and we will go on and perform and fulfill our obligations and hope that everyone else does as well. So contractors may not increase their prices by when faced by onerous conditions. Okay, now let's think of typical amendments. And I invite the audience perhaps at the end during question time to perhaps say some of their amendments that they've seen, which they have thought, well, that's not really fair. That's putting a lot more risk onto the contractor. So typically, shifting risk to the contractor. That's what it's all about and where I come from. That's what I see on a daily basis. And some of the amendments I've seen, the common amendments, ground conditions, we've mentioned ground conditions a number of times already. Ground conditions are a big risk factor. It's been said already today that risk should sit with the party best able to cope with those risks. Now imagine you have a contractor, could be an Indian contractor going into the Congo or Botswana or whatever. They've perhaps never worked there. The employer's building a factory, has built many factories before on the same site, and they understand the ground conditions. They understand if there's a shifting sands, rivers, subterranean rivers, or even if it's a brownfield site, a landfill site, which I had recently on one corner of a power plant. And none of the boreholes were there in that one corner of a power plant. All the boreholes were taken in other places. The cynic said that's where the employer wanted the contractor to see the borehole records as part of the employer's requirements, so it wouldn't be aware that part of it was actually landfill. And there was a dispute over the additional piling that the contractor had to place to cover the conditions of that landfill part of the site. So perhaps removing or amending the grounds for extensions of time relative to ground conditions would be a rather cynical and nasty thing for an employer to do, but it happens. Now, as I've said before, from the contractor's point of view, if they perform, their biggest risk is payment. They want to be paid in a reasonable time. The EIC makes the connection between suspension and termination, but I would say we step further or earlier in the contractual timeline, that the numbers of times that I've seen the 56-day payment period stretched is quite a few. It's one that contractors fight against quite correctly, because if you think of any company's cash flow, then staff may be weekly, staff may be monthly, suppliers may be monthly, subcontractors may be monthly. And if you think from by the time you've done the work, you put in your application for payment, your statement, it's reviewed. If the employer's engineer likes the form of the statement, that's another topic of debate for another day, perhaps. And then finally, some 56 days or so later from submission, you will get payment in full or in part. That's another debate. But to have that 56 days stretched, it makes it big call on the cash flow of the contractor. Red books don't tend to have advance payments. Yellow books and silver books tend to have advance payments, but that is soon gone by the works the contractor has to do before it gets onto site. And following my theme of cash certainty for the contractor, the number of times I've seen the clauses for suspension and termination for reasons adjacent to non-payment removed. Again, a big risk for the contractor. Generally, making things a little bit more difficult for the contractor to operate. Claims are always contentious. I don't like the words claims in a FIDIC contract. If I could suggest to Adriana that it was removed and substituted by entitlements, I'd be a far happier person. But the word claim suggests something that's contentious. So again, I've seen contracts with the subclause 20 notice period of 28 days reduced. The worst one I've seen is actually only 5 days. This is a clear attempt by the employer to have a fatal notice of 5 days such that the contractor will never have a valid claim. And if you think about it, that 28-day notice period was well thought of by the FIDIC drafting committee of the 1999 suite. If you look at the other obligations of contractors, there is quite a serious obligation for reporting, 4.21. For a contractor to comply with his obligations under 4.21, the contractor has to understand the status of its works. It has to understand its progress and what will affect progress. And as most claims start with a time issue, then if a contractor understands the state of its progress and what is going to affect it, it can, within 28 days, submit a valid notice. I side with the employer's side, if you like, that if a contractor cannot issue a notice within 28 days, then perhaps it's not a very professional contractor, and maybe it doesn't deserve the claim. That's perhaps a very harsh view, but as I say, the 28-day notice period does hang together with a monthly report. Again, you start to shorten things on the 28-day notice period, then it doesn't link up with the monthly report. And finally, on this slide, lessening the obligations of the employer is another theme that I've seen. A typical example, by deleting subclause 2.4, employers' financial arrangements. This clause is of paramount importance to a contractor. It's the clause that gives the contractor some certainty that the employer can pay the contract price, the whole contract price, or the contract price as per the awarded contract price, the tender bid, and as it's amended throughout the period of the construction, that it can pay that price. It has the funds to pay that price in accordance with the payment conditions. So if the payment conditions say for a yellow book or silver book, there will be massive letters of credit for the shipment of materials, equipment, and so on, that those letters of credit can be raised at the appropriate time. That not only is the funding available, that the funding is available and the ability to raise letters of credit is available. There are no impediments with the local banks, the national bank, or whatever, to gain foreign currency to pay the contractor for the equipment that is going to be shipped against that letter of credit. To see that removed is very dangerous. I have a project at the moment where there is a dispute over the raising of the letters of credit, and the employer wants to go from confirmed to unconfirmed letters of credit and also have clause 2.4 removed. I'll leave you to think on the risk for the contractor of that. Typical amendments to create more control for the employer. There are those employers around the world that wish they had never got an engineer involved and do not treat the engineer with respect. It's as simple as that. Employers that seek the engineer, or demand that the engineer ask for consent before the engineer fulfills some of its obligations and duties within the contract. Typically, the engineer needs to issue a variation for whatever reason. Red book, perhaps it's the engineer's design. Yellow or silver, it's perhaps because of something that's happened and there's a change to the employer's requirements. But they say you must ask for permission. It's not only a lack of respect for the engineer that you've appointed, it's also a time issue. For if this is going to be accepted into a contract condition, how much longer does it have to wait when a necessary engineer's instruction is made that will delay the works if it's not made? Going on, making a determination, a fundamental obligation and duty of the engineer, the fair determination of the engineer. But if you have to ask the employer before you can make a fair determination, that is an absolute contradiction. Whether that determination is granting an extension of time or recognizing additional payment for claims for entitlements. Before the determination, there's got to be a period of discussion between the contractor and the employer. But that seems to push that all out of the window by this one simple amendment that says, before you make your 3.5, you've also got to seek my consent. So employers that demand more control. And then a very typical one, especially in the Middle East, I've seen a number of times, remove the dispute adjudication provisions. Now, this is, shall we, this the intermediate step before arbitration. It's said to be, and it is, a swift resolution in the first instance of disputes. 84 days is the period that the DAB has to make its decision, its award. And to remove that is like a sword of Damocles. Arbitrations, as Jenny well knows and we all know, are time-consuming and expensive. I've worked with Keating Chambers on one arbitration, and I think we had something like 3 years from the notice to the award. To take out this 84-day buffer is not exactly fair play, in my view. It's putting a very big sword of Damocles, as I've said, over the contractor's head. It's a threat, because people will say to you, well, don't go to arbitration unless the claim is worth N million dollars. The dispute board will see the claims that are worth $100,000 or $200,000 or $10,000. And the dispute board can fairly dispense with justice in their own proper way. But to have this value of claim before you go over that threshold is terrible for a contractor. An arbitration, even with a dispute board, is a very distant proposition. I'm led to believe by eminent sources that it's something like 252 days from notice of claim to giving a notice of arbitration. So there is a lengthy period anyway. So why would an employer want to lessen that? It sees it as being a reason for not paying these smaller claims that is probably, if the engineers have to go to the consent to make an award, that will be rejected anyway. So there's a long period before arbitration. And actually, an aside, I think the period is even longer under the 2017 edition. Finally, forms for potential misuse. The first one, offshore wind. I have been involved with offshore wind projects, and they're of their very own nature. A lot of contracts where it's said to be FIDIC based. However, offshore wind contracts face the challenges of actually inconsistent weather and sailing challenges. One typical area for dispute is who controls the sailing of the vessels, the captain of the vessel, which is normally the contractor's man, or the marine warranty surveyor, which is normally the employer's man. It's been an area ripe for dispute, but I'm glad to see now that FIDIC are addressing that. And for me, again, on recent and current experience, where mayhem, I use the word mayhem, may be caused. Package contracting is a term in the USA and UK, where you have multiple contractors on one project. There are some very, very large coal-burning power plants in South Africa. I worked on one of those, and it was said that to construct that project, there were 38 FIDIC contracts, one red book for the civils and 37 yellows for all of the technical points, contractors, the turbines, the boiler, the EIC, and so on and so forth. As Venkat said, it is possible. It puts a massive burden onto the engineer for the employer to mesh in all these contracts. Claims are coming in from the civils contractor who said that the boiler contractor had given him late information for weights to design the foundations and so on. A mix of red and yellow, yes, it can be administered, but it is not what FIDIC intended, I believe. I think FIDIC could perhaps look at a package contractor contract. Now throw a silver book into that, as I've got currently, where there are 5 contractors, a civils contractor, a building envelope contractor, my client, which is installing the very technical purpose, shall we say, of the project, and then a mechanical electrical contractor, and then a landscaping contractor. My client accepted a silver book naively, but the engineer's representative is seeing them as the catch-all. The other contracts are all yellow books, and wherever anything is missed from their scope, he just turns around and says, well, you've got a silver book, it must be in your scope, where the scope, believe it or not, is quite well defined. So that is where I think mayhem could be called. And I would suggest that package contracting, you should look for some other method, maybe a lawyer that's been involved in package contracting and has a set of books that can be used, or set of contracts that can be used. That's a fair whistle-stop tour. I thank you for listening. And I wish you all good luck in achieving your goals of contracts that are fair, clear, full of good understanding, and providing certainty. Thank you very much.
Thank you, Paul, and thank you to all members of the audience for very attentively listening to us for almost the past 2.5 hours. In fact, our audience has been so attentive that they have been putting out questions as each speaker was getting through their presentations, and I thought it might be very helpful to run through some of them. I'll read them out, and the speakers can share their thoughts on these questions. The first question that I have is to do with the Silver Book, and particularly that it does not prescribe approval of contractors' documents by an engineer. So the participant has asked, up to what extent is the review and who specifically undertakes it, or is there simply an implied acceptance or simply non-objection? I think maybe we should hear Adriana's and Jenny's thoughts on this.
Okay, so the regime actually is the same under Silver Book or Yellow Book, because we have the same review period, and in the Silver Book, as in the Yellow Book, there might be a notice that the design does not comply, and also the same is applicable for commencement of execution of the works. If there is a failure to comply with the requirements, the contractor has to revise the design and resubmit it. So if you look carefully at the provision, actually the approval doesn't give us anything. It is just an approval if specified. Otherwise, the entitlements, the rights are the same. Because if you go to 7.5, you shall see that in case of non-compliant design, it has to be resubmitted, and there might be employer's claim in this case. I'm now in the end of a Silver Book 99 project where the contractor cannot start the taking over procedure because we still have some design which has to be revised. So the regime is the same. Even I remember there was an article by the European International Contractors complaining that yes, we are working on the Silver Book contract with a lot of risks, but at the same time, though it is a contract with no control, at the same time, the control of the design is like under the Yellow Book, so no difference. And what is the scope of the review? The scope of the review is only compliance assessment. Compliance assessment means with the employer's requirements, and of course, this includes compliance assessment with the applicable standards, applicable law. So this is the scope, and Jenny, you can continue, and I can share the new guide for everyone to see that now this different talking is no longer there. We have the same wording. We have now a defined term which is called no objection. So this is the procedure for no objection. After 21 days, if the employer or the engineer is silent, the contractor can continue. So it would be over the review period.
I would broadly agree. There's a tiny difference between the Yellow and Silver Book. Obviously, Yellow Book, you've got an engineer. Silver Book, you don't. So Yellow Book, you're submitting your designs to the engineer. Silver Book, you're submitting them to the employer. Under the Yellow Book, the contractor can't execute the works until the engineer has approved the contractor's documents, which include the design documents. But it includes a deeming provision in relation to that approval once the design review period has expired. Under the Silver Book, it doesn't require the contractor to wait until it's received approval, but it's got to wait till expiry of the review period. So they sort of achieve the same thing with slightly different wording, and one is submission of design to the engineer, and one is submission to the employer. Both provide that agreement or review does not relieve the contractor of their contractual obligations. So just because the employer has passed a given design doesn't necessarily mean that there's not going to be claims down the line for failure to design in accordance with the employer's requirements, for example. Not necessarily scot-free at that stage.
Yeah, you can see how good is to use a guide. If you have the 99 contracts, just use the 99 guide, because you can see comparison of the red, yellow, and silver. And after the relevant provision, you can see the comments. So this is the 2017 guide. I recommend you to have the guide.
Thanks very much, Adriana and Jenny. We have another question from a member of our audience, and I think maybe Venkat would be quite well placed to answer this because it concerns tendering. Venkat, the question that we have is, if a contractor makes a technical proposal and proposes some deviations in that from whatever the employer's requirements are, and is ultimately awarded works and submits an undertaking for that. So what happens in this scenario? What are the risks that the contractor is exposed to? Can he deviate? Does he have to comply with what the employer's strict requirements were?
Yeah, this is a major area of dispute. Generally happens in the Yellow Book contracts, especially in this part of the world. The employer requirements are normally not precisely written by the engineer or the consultants who are putting the contract documents together. They throw everything, like from a traffic study, any kind of information they have, they will just include it as part of the employer requirement and expect the contractor to do the design. So naturally, there will be a lot of contradictions between these documents. The contractor have to see what is relevant, and he has to sift through that, and he has to do a contractor's proposal. Unfortunately, although the contractor is making a proposal, based on that, he is going to put the price. Everyone would expect that that's how the contract should go, but it's not the case. If you go back to the priority of documents, the contractor's proposal is taking a lower priority than the employer's requirement in the priority of documents under the 1.5. Due to that, it may be that there was the pump capacity was wrongly mentioned in the employer requirement. The engineer might have changed, the contractor might have changed and given a correct one. But when the project is executed, I have seen that the employer wants to have a discount because the pumps supplied were smaller than what is mentioned in the employer's requirement. So this happens in every contract where the contractor is expected to do a design. So what we have devised a system based on our recommendation is, we have the employer requirement, then we have the contractor's proposal. Run through that with the employer. Some of the changes, the proposal by the contractor, the employer is willing to accept. Some of them he may not be willing to accept. Make a final version and sign by all the parties, and put this document in the priority of documents as a combined document, as a revised employer's requirement, rather than you have the employer requirement and you have the contractor's proposal. The ER taking upper priority over the contractor proposal, that would be avoided. So that's how we circumvent that problem in this part of the world.
Thank you, Venkat. Thanks. That's very interesting to have this practical perspective. And we have a final question for Paul. I suppose the question is simple, but I'm sure that we're very curious answer to it. Paul, what's the most outrageous amendment to a FIDIC form that you've seen in your experience?
The most outrageous. I think I probably alluded to them. In my talk. I will take the most outrageous theme, and I think that's the poor cash flow for the contractor. That the employers seek to stretch the payment terms to avoid clause 2.4, sorry, and then perhaps remove the suspension and termination, or amend the suspension and termination conditions. So everyone I think on the panel and everyone in the audience should be looking for balance, proper risk allocation, to allow a degree of certainty, high degree of certainty, hopefully. And I think when risks are shifted from one side where they should not be shifted for whatever reason, that's going to be thrown out of the window. And there's a bad atmosphere, if you like, from day one, no matter what people say. I think that's probably the most outrageous one I've seen. It's the theme of cash flow for contractors. Adriana's perhaps on the other side of the fence more than me. Adriana, would you like to comment?
Yes, of course. I have seen in my experience a huge problem with payment of variations. Employers always forget that variations should be paid as long as they are executed, no matter that you have not reached an agreement or there is no determination, so you have not fixed the price. If they're executed, they have to be paid. In many cases, this leads to suspension and termination in my experience, because ministries, these government organizations are very slow in the process of approval of additional financing. And they consider that if they're paying within the provision of the contract, everything is okay. But when the variations reach 1 million, then the contract just suspends the works and thinks about termination.
Thank you.
Thank you. Thank you, Adriana. Thank you, Paul. Thank you, Jenny. Thank you, Venkat. And thank you, Mr. Singh, for helping us open this series with the first session. I would like to at this point also thank our audience for sitting through very attentively, and would like to bring this to a close by saying we hope to see all of you at the second session of this series, which is scheduled to happen on 31st March, um, about a month or so from now. And those of you who have registered, you will receive updates over email. Thank you very much and have a good evening.
Thank you. Thank you, everybody.
Thank you. Bye.
Thank you. Bye-bye. Bye-bye.